jury will not be sequestered.
I'm Brian Buckmeyer, along with Terry Austin.
In the Weinstein case, fellow silence breakers and any
Selection is moving along
Well,
here.
I'll read the verdict, says Jesse Weber. Thanks for joining
We
us.
don't tend to see it as raw as this.
Good evening and welcome.
All right, welcome back to the Law and Crime Network. My name is Bob Bianchi. I'll be your host at 3 o'clock. A lot on the plate today, but as you know, Ahmaud Arbery, jury deliberating for only 11 hours, coming back with substantial charges and convictions, all defendants facing life in prison. We're also covering Colleen Maxwell. That's the case where Jeffrey Epstein, she is accused of working in concert and conspiracy with him in order to groom underage girls, 4 victims in particular, although they'll testify about 6. She is facing a significant decades-long state federal prison sentence if she is convicted. We don't have cameras in the court because it is federal court, but we do have a reporter that's on scene who will give us the updates with regard to what is happening with regard to that case. And lastly, we have New Hampshire versus William Argy, 48 years old. He is accused of murdering his wife of 14 years for, the prosecutors say, motive being a $400,000 insurance policy and a marriage gone awry. Right now, the state's case is in past opening statements just today, and one of the friends of both of them is testifying and is now being cross-examined by the defense attorney, so let's go live to court.
You were supportive of her plan to leave Bill, is that right?
Yeah.
You encouraged her to leave Bill before March, is that right?
I don't remember.
When
That I
Maureen would
encouraged
speak with
her.
you about her unhappiness in the marriage, you didn't pressure her to stay married.
No.
You wanted her to leave Bill.
I wanted her to be happy.
Okay. Now, you were friends with Maureen for about 20 years, you said.
Yeah.
So the entire time you knew Maureen, she was with Bill?
No.
Okay. So Bill and Maureen met after you and Maureen were already friends.
Correct.
And during those 20 years, you were mostly friends with Maureen, right?
Yeah.
You weren't close with Bill.
No.
Did you particularly like Bill?
No, we didn't really gel.
You didn't, Joe?
Yeah.
No. You thought he was loud.
Yeah.
You thought he was obnoxious.
Sometimes.
You thought he could be pig-headed.
Yeah.
You thought he talked about himself too much.
I don't know.
Okay.
Maybe.
But you didn't like the way he treated Maureen. Fair to say?
Correct.
Now, back in March of 2019, when Maureen was planning to leave Bill, you were aware of her plans going forward.
Yes.
She was going to be moving to Manchester,
Yes.
into Bill's mother's home.
Yep.
You said that was a temporary move. Did she have plans for how long that might be?
I don't think she'd gotten that far, no.
She hadn't gotten that far. And why was she going to move in with Brenda instead of to something more permanent?
I think the finances were an issue.
What do you mean by that? Finances were an issue?
I don't really know the details, but that was the impression I got, that she didn't feel like she could make a final move right away because of finances.
Okay, so she couldn't afford a down payment on a house. Is that right?
Correct. I mean,
You
they had a house, so.
Right, right. But a house that they were going to put on the market, is that right?
I don't know.
You described Maureen as, quote, holding down the fort.
Mm-hmm.
She was primarily responsible for taking care of the kids.
Yes, and working,
She worked
holding a
full-time.
job, yep,
She was a social worker.
yep.
Did she feel like she could rely on Bill for help with the kids?
No.
No. And you and Maureen were close.
Yeah.
You saw each other regularly.
Yeah.
You talked regularly.
Yeah.
Maureen would confide in you.
Yes.
She would tell you about her marriage.
Yes.
She would tell you about her unhappiness.
Mm-hmm. Yes.
She told you about her worries about Bill,
Yes.
about his mental health.
Yep.
Maureen never told you that Bill was physically violent with her.
No.
You never saw her with bruises or visible injuries.
No.
Maureen never told you that she was afraid for her own safety.
She said that he postured one time in a
postured.
doorway.
Okay.
Mm-hmm.
But Maureen never showed up unannounced, needing a safe place to stay.
No.
She never asked you about domestic violence resources.
No.
But you worried about Maureen, right?
I did, yeah.
You worried about her safety,
I did.
and you asked her if she was safe at home,
Correct.
and she told you she was safe.
She said she felt safe.
She felt safe.
Mhm.
Okay. One moment. Nothing better.
Any redirect?
Yeah, she qualified it when she said she felt safe, right?
Yes.
And one of the qualifications is that she checked the house to make sure her husband didn't have access to weapons, right?
Correct.
And the other qualification was she was told to tell him that she would call the police if he threatened her, right?
Correct.
Thank you.
Any recross?
No.
Okay, and may this witness be excused by both sides?
Yes, Judge.
Okay, thank you. You can step down, you can stay or leave as you choose. And ladies and gentlemen, and since we're now at around 12:06, give or take, why don't we break for our luncheon recess? If I could have everyone back at 5 past the hour, that'd be great.
All right.
Okay, there you have it. We have Gentleman Wong with us, who is a civil rights attorney, and Mike Koribanics, who is a law and crime legal analyst and certified New Jersey Supreme Court criminal trial attorney. Okay, so Mike, give me your rundown on the case so far. The prosecution seems to have pretty good motive in using witnesses that know the individuals at play here. Basically, this one's saying she was concerned about Maureen, the wife's safety. What do you think so far, Mike?
Well, this case is going very methodically so far, what I've seen. In fact, I've seen the defense attorneys, which I always credit when they don't cross-examine. There were some witnesses here that she really had nothing to get out of cross-examination. I think the defense is trying to build its credibility with the jury, but I think the defense also has to figure out what exactly is going to be their defense here. I think we might have gotten a little hearing of it when she discussed the defendant's mental health issues.
And Genvin, am I saying that right, Genvin? Is that the correct pronunciation? All right, there you go. Awesome. First Genvin I ever met, so great to have you on the show. Welcome. So, talk to us a little bit, Genvin, about this whole issue permeating like domestic violence, and ultimately we're going to hear that she actually called the police to say, hey, to make sure the phones were working, the lines were working, because she was concerned about domestic abuse. How heavily will that play in the jurors' minds, do you think, with regard to whether or not the husband actually murdered her?
In these kind of cases, the primary suspect is always going to be the spouse, right? But when you throw in this issue of domestic violence, it's something that happens quite often. There are so many victims of domestic violence that wind up being unheard, who wind up being hurt. And oftentimes, domestic violence does spill over into, unfortunately, these situations where homicides occur. And in this case, it's setting up the scene, and it's setting up the context of a motive, an opportunity. It just sets up the whole mindset for the defendant and why he would have done what he did. And I think it's going to help the prosecution in this sense.
Yeah, Mike, to Jenvin's point, when I was prosecutor, I always used to say to our family unit that today's domestic violence is tomorrow's homicide. So you have to be extremely careful with regard to how you go about disposing of those cases or handling them as far as law enforcement matters are concerned. So that obviously is going to play heavily in this issue. But then again, there have been cases murder cases we've handled, you and I, where the suspect was the domestic potential abuser or the spouse or the divorce gone wrong, and it turned out not to be that person.
Well, like always, Bob, and that's why sometimes when people say, especially with prosecutions, they want to hear the whole case at the initial press conference. Yet, there's so much discovery that needs to be gone through, so many issues that need to be closed off. Investigations take a long time. And even in this day of video and all kinds of technology, it still takes about 3 or 4 days to go over a 5-minute video.
Mike, that is such an excellent point that everybody wants it all concluded at the press conference. Know the pain very well because we go slow and steady and the media wants it faster, wants it before it actually happens. So we'll have to see what develops in this case. But so far, it sounds like the prosecution's got a pretty solid case from their opening statements. And so far, the witnesses they put on, we will see what develops. We're going to take a quick break. We'll be right back. All right, Ahmaud Arbery, as you know, the shooting death of him has been convictions across the board. Sound defeat for the defense attorneys in the case. Jenvin Wong and Mike Koribanics are with me. And so, Mike, let me go to you first. We've covered this extensively. What is, in your mind, the message of this verdict?
Well, the message of this verdict was that, number one, is that this is why people should not take the law into their own hands. They're not trained professionals. They don't know how to handle certain situations. And quite frankly, this whole tragedy occurred because of a rush to judgment of people concluding things they were not trained to conclude.
Yeah, and Travis is the only one who took the stand in the case. Like, that kind of made sense to me from a defense strategy and when you're asserting a self-defense claim, I think you need to put the shooter on the witness stand, but the other two want to kind of stay away and distance themselves a little bit. But the jury didn't buy it. The jury found that all of them acted basically in concert with one another. So did this verdict surprise you at all?
No, it did not. No, it did not at all. And I thought, Bob, and I thought the same way you did about when they put him on the stand because of the self-defense claim. However, I didn't agree with their procedures of trying to show that he was basically an untrained, trained professional. I don't think that helped them because if you have a limited amount of training, you know how important everything is. So that would say if I'm not a trained professional, I would notify law enforcement to handle the situation. And I think that was not a very good tactic.
Yeah, Mike, one other thing, people were comparing this to Rittenhouse and the differences in the verdict. And I kind of speculated that when you're dealing with cases like this, of course, it's comparing apples and oranges. They're two completely different kinds of cases. But in both of those cases, the person was running away from a crowd of people. And that makes it much more difficult to argue that they're the actual aggressor in a self-defense case. What are your thoughts about that?
Absolutely. I mean, if someone's trying to, how could they be the aggressor if their back is turned toward the person who is chasing him and things of that nature? I think that's always a very difficult burden to overcome if you're a defense attorney to try to show self-defense.
All right, so let's just go take a look at the verdict, and we'll come back on the other end and have some more commentary.
Count 2, felony murder. We, the jury, find the defendant, Travis McMichael, guilty. Count 3, felony murder. We, the jury, find the defendant, Travis McMichael, guilty. Count 4, felony murder. We, the jury, find the defendant, Travis McMichael, guilty. Count 5, felony murder. We, the jury, find the defendant, Travis McMichael, guilty. Count 6, aggravated assault. We, the jury, find the defendant, Travis McMichael, guilty. Count 7, aggravated assault. We, the jury, find the defendant, Travis McMichael, guilty. Count 8, false imprisonment. We, the jury, find the defendant, Travis McMichael, guilty. Count 9, criminal attempt to commit a felony. We, the jury, find the defendant, Travis McMichael, guilty. Dated this 24th day of November, 2021, signed by the foreperson. Have a seat.
You know, Mike, I call this the quatrain of the gun violence in both of these cases. In the states where you're allowed to carry these weapons, and I know it's a debatable issue, I'm not making a political point of view here, but you carry these weapons and it's very commonplace. It's different than it is for us. Me and you've talked about this in Jersey and New York, where people aren't allowed to carry AR-15s. They then go to the location. Both these defenses seem to be the same of Rittenhouse and Travis McMichael. Then there's an altercation and they're in fear. That's the second piece. And then the person who's having a weapon pointed at them, who's probably also in fear, goes to grab that weapon. That's the third piece. And then because that guy goes to grab the weapon, and this training is this way, I was trained in this. Now there's a potential of lethal force being used against you if you're disarmed. And so that gives them, in their minds, the justification to use lethal force. Really toxic combinations of this gun quatrain that I refer to, no?
Oh, Bob, it's confusing. It's flexible, which you really don't like to have statutes of this sort to be so flexible. You bring a very good point. If someone's attacking me with a gun and I'm reaching to get that gun out of the way, how all of a sudden does under the law that shift to make me the aggressor? These self-defense laws, I think, really need to be re-evaluated and to be looked over again, because many of them were written prior to so many new kinds of weapons out there. And I think they sort of have to come up to the technology that is out there with the shootings. I mean, we saw that in the one part of the Rittenhouse case where the weapons offense was dismissed because they weren't making weapons that long when they originally wrote that statute, is my understanding. So I think a lot of these statutes need to be reevaluated.
Yeah, I'm not 100% sure about the reevaluation of the self-defense law. It kind of makes sense to me. It just creates this toxic situation when everyone's allowed to be out there carrying guns, and when people are trained, Mike, that once somebody grabs your weapon, you are in serious bodily injury or death could occur. It just creates a really, really strange scenario. But maybe some laws change for sure, to your point. All right, well, listen to Travis McMichael, direct examination, and he was testifying for his life here, and obviously the jury didn't buy it, but nevertheless, there were some who felt that he made some impact on the jury. It'd be interesting to see what they thought about his testimony down the road if we ever get a chance. Let's take a listen.
You see in the video, we all see in the video where you raise your shotgun.
Yes.
You see that?
Yes.
Okay. You remember doing that?
I do.
Why'd you do that?
He was closing in. At this point, I've yelled at him to stop several times. At this one again, I screamed at him to stop, screamed to stop. He is focused in on me, and he's at this gate where he's looking like he's about to run. He has the possibility to get this burst out. And if he gets this burst out at this point when I pulled the shotgun, I wouldn't have time to react if he wanted to get on me or to pull a gun or have a knife, or if he wanted to do ill will. At this point, this is when I needed to show him to deter him to do not come at me.
How do you know at this point you have to do that?
Because everything that's happened, everything that's going on, and him closing in on me.
No, I mean, how do you know at this point that you have to raise the gun, or he could be on you like that?
From training and prior experience. There's a thing called Tooler drill.
A what?
Tooler drill.
Okay.
A 21-foot roll, I think, is popular anyway.
Okay.
It says that any average person, it takes 21 feet for somebody to react. It's an average of 21 feet for somebody to react, to pull a weapon and fire 2 shots at somebody that charges you with a knife or anything like that. Mr. Arbery's already running. He's at a pretty good clip. He's directed at me. He sees that I have a weapon. I'm yelling at him to stop, and he's continuing. At that point,
he sees that you have a weapon.
Mm-hmm.
How do you know that he sees you have a weapon? What do you do?
I had the weapon out at this point, and I had it down at a position like this. Port arms is what they call it. Okay. And it's blatant that I had this shotgun.
Mike, we got a couple of pieces here that I think are important. It was clear to me when he was testifying that he has gone through firearm training. We know that he was in the Coast Guard. When I went through the Police Training Commission training in order to carry a weapon as prosecutor, it's one of the best things I ever did, to be honest with you. So I got to see how the cops are actually trained. So he's using the lingo there, right? So you're allowed in the use of force continuum, verbal commands, and then you can escalate to pulling your weapon out, even if you can't use lethal force, even if it's not justified, as part of what they call a constructive authority in order to try to get them to back down. And if the person still comes at you and you can't use lethal force, you're supposed to reholster. But this is essentially what he's talking about. The jury wanted to see the videotape of the actual shooting. Do you think, though, that they may have gone to a point where they said, you know what? The fact of the matter is this was a self-created situation. It wasn't a citizen's arrest. And so they just weren't justified under the law from the get-go. And that's why they convicted him? Or do you think they also said, and you know what? This is not a proper self-defense claim?
I think both. I think the proper self-defense claim really dictated the pace. I really don't think him showing limited training and then thinking he could go out at someone who is fully trained, who does it every day, and then justify his actions never made sense to me. That's just me as a valid defense, because you would think someone who's trained or has gone through training like you do, like you have, Bob, but you show respect for law enforcement and who to contact. I don't think you necessarily, or anyone would necessarily, who's not trained handling this every day, would put themselves in this type of situation. They simply would know enough to call trained professionals to handle a situation and not put another human being's life in danger.
Right. One of the things they tell you, constructive use of force, if you identify yourself as a law enforcement officer, your badge, your gun, your uniform are all indicators communicating to the person to back down. This citizen's arrest law they have in Georgia, though, at the time, we know it's changed, did not have any of that. So how was Ahmaud Arbery supposed to know that this person, by the way, is affecting some sort of citizen's arrest, assuming you even want to believe that, as opposed to a mob of people chasing him down the street? He was in an impossible position at that point in time, no?
Well, I think it was more suggestive that there was a mob coming after him in separate cars, taking videos, guns showing, than actually someone trying to find out, number one, did a crime occur? Or number two, is somebody okay or is somebody hurt? I think it was very clear from the beginning of this that he was being chased by a mob.
All right, Mike. Yeah, excellent. Certainly that is what the jury found. So they are facing life in prison sentences. We will see what happens when the judge ultimately sentences, whether or not any of that's going to be without parole, the possibility of parole, but at least a minimum of 30 years in before they can even be eligible for parole. We're going to take a quick break. We'll be right back.
He thanked me, and we said we'd get together and talk about it after we've had some time to reflect and settle down. He wanted to get out of here because of security issues and things like that, and that's what happened.
All right, switching gears back to Rittenhouse, that's Mark Richards, the defense attorney, having scored a very successful win against the prosecution, a well-fought-out case by both sides. We're now being told that University of Arizona students, where Kyle Rittenhouse is in attendance, no longer want him on campus. They want him thrown out, referring to him as a racist and a bloodthirsty murderer. Mike Koribanics, is that what the evidence showed?
You know, Bob, it gets back to what we spoke about earlier. This young man was acquitted by a jury. I think those people who were making those protests of that nature at the university should be asked, did you sit through and see all the evidence of the trial? Did you sit through it like the jurors? Because everybody wants to get to everywhere else about a trial except going to the very basics. There was a jury there, and they decided the case, and they looked at every piece of evidence. I think that should be the first question they ask the students who are starting this rally.
Mike, that's such a good point, because so many were commenting after the verdict about what a travesty of justice is. I understand people have a political point of view, but lawyers look at facts and we look at law, and that's it. And we watched this case gavel to gavel here at the Law Crime Network. Me and you broke it down, and they were still repeating narratives, the elected officials and others, that just did not come, not only did not come out in the evidence, was clearly belied, contradicted by the evidence. Why is it that people can't put aside their political points of view and judge things based upon what they see at trial? And why are they commenting on trials they never looked at in the first place? I'm pretty confident most do not sit there and watch the entire trial like we did.
You know, Bob, and even though we watch trials, we sometimes have to watch them 2 or 3 times when we're doing our own trials. We're always reviewing that night. There are things that are just not always brought out to the attention of people in the trial, and I think it's very difficult when people criticize a trial, but they haven't followed it. The jurors take no time off. They are in the jury box watching testimony, reviewing evidence during their whole deliberations and during the whole trial. And I think that's an important thing. I don't know, Bob, but it troubles me that people start with conclusions before looking at the facts.
Got a couple of things here, Mike, with this. First of all, there was no evidence whatsoever produced by the prosecution with regard to any belonging to any kind of supremacy group or anything like that. They had his electronic data, downloaded his computers. The evidence just did not support that. However, he did appear at a bar at one point in time and was taking pictures with individuals known to be far-right extremist or supremacist groups, and indicating also that he may have thrown a sign, a white supremacist sign. Rittenhouse certainly, even though innocent, didn't use the best judgment with regard to either that night or what he did afterwards by doing that. Could that be a basis for their claim?
Well, I think it could be, because everything is, Bob, we're in the world of Instagram. Everybody likes to post one picture and describe a whole event within 10 words or less. That's not very possible. At least it's not possible when you're seeking justice and seeing that our system moves along. I think it's a very difficult position.
Yeah, sorry, Mike. Jenvin is back with us. Jenvin, I'm curious about your opinion as a civil rights person. I mean, we have a presumption of innocence. The government was not able to overcome that beyond a reasonable doubt. They did not introduce evidence with respect to white supremacy groups or racism or anything of that nature. It was 3 white people that were shot. Irrespective of the politics of it, usually those on the more liberal side of the equation are looking for criminal justice reform and believe that people are being over-prosecuted and should not suffer consequences after they've been found not guilty. Why is it different here? Maybe I'm mute, Jenvin. I apologize. Maybe I'm mute.
I apologize for that. But this case was being followed very closely because of the circumstances in which the incident took place, right? It took place during these uprisings for social justice, for racial justice. And what we looked at here was this case being tried in the court of public opinion before it even got to trial. And even as it was at trial, it was being tried in the court of public opinion. But the other thing we have to understand is that people now know, it's not just the Rittenhouse trial. It was being tried at the same time as the trial of the 3 men who murdered Ahmaud Arbery. And what we have during this political climate here is this understanding now that the criminal legal system is flawed. We don't always get justice from the criminal legal system. And what we saw here is that the criminal legal system does have its limits. And, at trial, Rittenhouse, of course, has a presumption of innocence. Of course, his defense, really worked and did their job here. And the prosecution, unfortunately, failed to prove the charges beyond a reasonable doubt. But that doesn't mean that justice was served. And I think that people are understanding that the criminal legal system is not such a black and white, excuse the pun, black and white kind of system, that there are gray areas and that the criminal legal system can and has in the past failed to deliver justice.
Yeah, Jenvin, it is a human institution. And no matter how many laws you write on the books, I mean, I ran an agency for a lot of years. No matter how many things you try to do, you're still being run by flawed people. We're all flawed. That said, when the state's case was going in, a lot of commentators here on the liberal side and the conservative side, I, for one, listened to 3 or 4 witnesses that I could not believe the prosecution called. They had to call them, but they actually supported this self-defense claim. They showed that he did not travel to Kenosha with the AR-15, that it was already in Kenosha. They showed that he did have contacts with Kenosha when it was argued that he did not. They showed that he was taking graffiti off walls and that he was trying to help people with medical issues, saying friendly, friendly when things were getting hot. In fact, the 3rd victim in this case actually said that he thought that Rittenhouse was in serious danger because the crowd turned their ire towards him, started threatening to kill him, and then we all know what happens. He's running away from them, and he's being hit with rocks. Gunshots are being fired behind him. He gets hit with a skateboard repeatedly, gets kicked violently in the head while he's down on the ground, and then somebody comes at him with a handgun, which he doesn't even point his weapon up until that person takes the handgun and points it at his head. Could it just be the jury saw it as a self-defense case?
Well, they clearly did, right? I mean, they delivered that acquittal. And like I said, I think that this was really an example of the limits of the criminal legal system, and also an example of what a really robust defense can do for you, combined with a failure of the prosecution. And that's really what happened here. And you know, when people have made comments about the Rittenhouse trial, I think what is missing is you have to look at it in the context of how other defendants who may have similarly situated to him may have been treated, who may have been, you know, not as young as him, or who may not have appeared the way that he was able to appear at trial, which is pretty well kept, very well prepared, with a good defense team. And you know, he's a young white guy. I mean, this is the other thing about it. You know, that jury comprised mostly of you know, there weren't a lot of minorities. It wasn't a very diverse jury. Now, we can talk about the legal standard about beyond a reasonable doubt, but
yeah, but Jeff, I'm trying to push back a little bit. But so were the victims. They were all young white people as well. The thing that I think here was the thing that became more of a racial issue in my mind than the Ahmaud Arbery case, which surprised me because there was a black victim there, was that he was in support of or going there in support of Blue Lives Matter, or in support of the cops, against the people who were committing damage and burning buildings down and things of that nature. Does that come in your mind anywhere near close to calling him a racist? And in terms of the fact that there's just simply was no evidence of that. In fact, and let me just finalize that. There's not even a federal civil rights claim filed against him, as there is with Ahmaud Arbery.
you're absolutely right. I think that this case was a little bit more difficult to prove in that sense. But I also think that when we're talking about the context, yes, the victims were white, but the victims were there standing up, and they were protesting for social justice, for racial justice issues. And they were there protesting for that. And in that sense, it became a very highly charged issue. It became a lightning rod, especially for the far right, right? And you saw the far right really put Rittenhouse up on this pedestal. And I think that's part of what made this a little bit more difficult. And as I said earlier, this is a case that was really tried in the court of public opinion and in the press before it was tried in a court of law.
Yeah, Jenvin, I think that was right on the money. I think that because he was being adulated by the far right, and it was a Black Lives Matter protest about police violence, and then the narratives are being created. But, you know, us as lawyers, we look at facts, law, and videotapes, and then, you know, try to respect the decision of the jury. And I think that decision, by all estimations from the people I had on the show, were very much after the state's case right there before he even testified. Didn't think there'd be a conviction. Certainly, they thought maybe a hung jury or not guilty. Okay, let's listen to Mark Richards a little bit more on the defense attorney in the case with regard to some of his commentary. A very interesting guy.
Do you want the truth?
Yeah.
Yeah. When I took this case, I had initially saw this happen. I saw the reports on television, and I thought to myself, what an asshole. And then I started looking into it a little bit before I was hired. There was more video out there, and I thought this kid's getting railroaded. And I don't know that it's happenstance, but a woman who was with the defense team, who I think is a really good lawyer, Marina Medved from Virginia, contacted me and asked me if I'd be interested in getting involved, and I said I would. And the more I worked on the case, the more I thought it was defendable, not necessarily winnable. But it was from a defense standpoint, it was a great case to have. There was no middle ground. We never once approached the district attorney's office regarding a plea agreement. They never once called us to offer one. So it was a war. And in the end, we came out on top. Once I looked into it, I wasn't. I thought he deserved a defense. I thought it was a very defendable case, and I don't think the story was coming out. You know, I've told numerous people this story, but when it was announced that I was joining the defense team, my daughter, who was at that time living in California, called me up and she yelled at me. You know, she goes, "How can you represent that racist?" and laid into me. And she means a lot to me. And I said to her, I go, "Look at these 3 videos." And I sent her 3 videos. I don't know whether they were compressed or not, but they got to him, and she goes, "Dad, that's not what everybody's reporting." And I said, "I know." And that's...
This from my standpoint, even as a former prosecutor, that is why we have defense attorneys. Everyone is entitled to a fair trial, the presumption of innocence, proof beyond a reasonable doubt. And defense attorneys have a tough job to do. That was a very interesting clip. We're going to take a quick break here at the Law and Crime. Don't go anywhere. We'll be right back. All right, the case began against Colleen Maxwell today in federal district court in New York. We've been waiting for about a year for this trial. She is accused of working and conspiring with Jeffrey Epstein in order to lure and groom underage girls as young as 14 for his and her sexual escapades. There are 4 victims that are listed in this indictment, charging very serious offenses, including sex trafficking and enticement of a minor for purposes of committing illegal sex acts. The FBI made this arrest last year. Let's listen to the assistant director of the FBI, because unfortunately we don't have cameras in the courtroom, but this will give you a good glimpse as to how the FBI saw the case.
Almost 1 year ago, when our offices stood before you and announced the arrest of Jeffrey Epstein, I stated that preserving the innocence of children is among the most important responsibilities we carry as adults. Too often, adults in our society have turned a blind eye to the type of criminal behavior that we announced back then and announce again today. The villains in these outrageous crimes are the adult perpetrators, not the youth, who are our neighbors, our students, vulnerable foster children, and teens seeking support. Today, we announced the arrest of one of the villains in this investigation. Early this morning, Ghislaine Maxwell was arrested in Bradford, New Hampshire, by FBI special agents and NYPD detectives from the FBI NYPD Crimes Against Children Task Force. Our team from New York was assisted by special agents assigned to our Boston, Newark, New Haven, and Albany field offices. We've been discreetly keeping tabs on Maxwell's whereabouts as we worked this investigation, and more recently we learned she had slithered away to a gorgeous property in New Hampshire, continuing to live a life of privilege while her victims live with the trauma inflicted upon them years ago. We moved when we were ready, and Ms. Maxwell was arrested without incident. Like Epstein, Ms. Maxwell chose to blatantly disregard the law and her responsibility as an adult, using whatever means she had at her disposal to lure vulnerable youth into behavior they should never have been exposed and which creates lasting harm. We allege that from at least 1994 through at least 1997, Ms. Maxwell assisted Jeffrey Epstein's abuse of minor girls by helping to recruit, entice, groom, and abuse children under the age of 18.
My Koribanics, let's break down a couple issues here that I think some are kind of skirting around. First off, the enticement charge, persuading, inducing, enticing, or coercing a minor. It does not matter if the minor consented to it, and it does not matter whether or not they actually finish the act. It's the mere enticement of that individual to commit an illegal sex crime that gets them into hot water. In this particular instance, they are arguing things like Ghislaine Maxwell, she would give them money, she'd bring them to the movies and restaurants, get them into the room with the defendant Epstein, and then they would give them massages. Sometimes she would undress in front of them. She started to sexualize them, if you will, and then it tried to induce minor victim 4 to actually get other young girls to come in to do the same thing. Talk to us, Mike, because I know how serious, I don't think people get it, these enticement charges are in terms of a conviction.
Oh, they're extremely serious, Bob, because it's going to contradict everything the defense is going to try to put forward. I would assume the defense is going to try to show that Epstein manipulated her and she didn't know what she was doing and she didn't know that she was putting children at risk for these instances. They're going to be walking a tightrope in the defense. But I think the very fact that someone is going out, enticing these children to come to various different places, buying them gifts, things of that nature, it is not going to sit well with any juror. And how are you going to have any juror on that jury that doesn't have any sort of relationship with either their own children, nieces, nephews, things of that nature? Very difficult defense cases.
Right. Okay, Mike. Let's listen to a little bit more of the assistant director.
I'd like to take a moment again to speak directly to the victims. There never was, nor shall there be, an excuse for the criminal behavior you were subjected to. We know that your quest for justice has been met with great disappointment and that reliving these events is traumatic. When we met you, we told you that in the eyes of the FBI, you come first. I would like to thank you for the trust you place in our investigative teams as we work to hold the adult perpetrators accountable. For the many victims of other adult perpetrators who may be listening or get word of today's announcement, the example set by the women involved in this investigation has been a powerful one. They persevered against the rich and the connected, and they did so without a badge, a gun, or a subpoena, and they stood together. I have no doubt the bravery exhibited by the women in this investigation has empowered others to speak up about the crimes that they have been subjected to. If you are listening today and are the victim of child sex trafficking, please call 1-800-CALL-FBI or contact us online at tips.fbi.gov.
Gentlemen, you know, the thing that really is maddening about this case is they had Epstein bagged in 2005 with a very significant good case, and both state and federal prosecutors, it's so obvious. We deal with these cases all the time as criminal defense lawyers. We know the penalties. I know as a state prosecutor, 36, I believe it was, young girls that they had. The police were outraged when he essentially got a very lenient county jail sentence, most of which he was allowed to spend outside the county jail. And now we go years later and we have a plethora of more victims here. What are your thoughts about the case, Jen?
This case it's a terrible case, right? And everything that we know about the case so far, it shows that they're going to have a really hard defending this because it's textbook trafficking. The enticement, the gifts, the way that these young girls were groomed and the way that these young girls were recruited, and even using these girls to recruit more victims, it's textbook human trafficking. And that is, that's going to make it very hard for the defense here. And not only that, but because Epstein is viewed as not really having paid for his crimes, not having ever really been able to bring justice to those victims, this is the last chance, I think, for the prosecution to really bring forth justice for the victims with this prosecution against Ghislaine Maxwell.
Right. And Mike, let's go to the federal sentencing guidelines, which I know you are an expert and a pro at. We've actually worked cases together on this. I mean, if there was a conviction here, there are serious sentences, in my mind, a minimum of 10 to life in some instances with these charges, not to mention the cross-references in the code. She doesn't get acceptance of responsibility credits because she took the case to trial. If she's convicted, would you pretty much, based on your experience in the federal court system, agree with me that she's basically never going to see the outside of a jail cell again?
I would agree with you, Bob. And also, you bring out a great point because the federal sentencing guidelines are so different than state because of the chart and things of that nature, and the points you earn and the points you lose. And the other thing, too, is throughout the trial now, this judge will hear everything that happened. So he will also be able to bring into the sentencing to enhance it, should she be convicted, relevant conduct. That means things that she was not charged with but may have come up during the trial that may show the judge that she deserves a stronger sentence.
Yeah, Jen Vin, that's a really good point that Mike brings up. The relevant conduct that a judge is allowed to take into consideration in federal sentencing can really wallop a defendant at trial. And given this particular kind of case, I don't think there's going to be a lot of sympathy factor for her should she be convicted. Your thoughts?
I think it's going to be really hard to have any sympathy for her at this point. It's going to be a real challenge for the defense. A good defense attorney will be able to find something to bring forth here. But given what we know about Maxwell and her association with Epstein, I think it's going to be really hard for her to garner any kind of sympathy. And if anything, she is going to be facing the real threat of enhancements in sentencing.
Yeah, Jennifer, real quick, I got about 15 seconds. The defense has to be very careful how they cross-examine these victims here, especially given it's not just one, it's four with very consistent themes. What are your thoughts?
It's always hard to cross-examine victims of sexual assault, and especially victims who have gone through this kind of traumatic experience. So the defense is going to have to be very careful, but they're going to have to find a way to be able to cross-examine them without without coming off in a way
Mhm.
that they're
Right.
attacking the victims. That's always hard.
Right, right. All right, Ghislaine Wong, criminal defense attorney, civil rights litigator. I know you have to go. Greatly appreciate your time. Great having you on the show. We're going to be back with more and more on crime. Please stay with us. We'll be right back.
Those people that march, I'm talking about the people here that was here when nobody else was here. They stood up.
Okay, the Reverend Al Sharpton discussing the case after the conviction in the shooting death of Ahmaud Arbery. As you know, the three men were all convicted and facing life sentences. Travis convicted across the board, facing a life without parole. Jury clearly denouncing the defense strategy that these were individuals that were trying to protect their community and that Ahmaud Arbery was up to no good. I think trying to play the sympathy card with the jury, hoping that at least one juror may hang, but all 12 came back very quickly, 11 hours, considering all the charges and evidence that they had to go through. A resounding win for the prosecution. Let's listen to a little bit more of Reverend Al Sharpton.
Brunswick, Georgia will go down in history as the place that criminal justice took a different turn. Let us pray. Thank you, Lord. Dear God, we come thanking you for your mercy, thanking you for giving us a prosecutor's team that when it looked to us like the stacks, they'd stack the jury, that you still found a way to open up the minds of people. Took a young unarmed boy that they thought was worthless, and you put his name in history today. Years from now, decades from now, they'll be talking about a boy named Ahmaud Arbery that taught this country what justice looks like. They kept on marching and let us know that all whites are not racist and all blacks are not worthless, that we're all your children, and we will give you the grace and give you the glory. The glory be yours, not ours. Let us not be proud and let us not be vengeful, but let us be thankful that you brought us closer together today. These blessings we ask in your name and your sake. Thank you, Lord. Thank you, Lord. We never had a Thanksgiving day like today.
All right, Ghislaine Wong couldn't stay away. She wanted to do another. We wanted her to do another. She wanted to do another half hour. So here she is. Thank you so much, Ghislaine. You are a criminal defense attorney and civil rights litigator. I had a lot of civil rights background in my career as well. So what do you think about what the Reverend is saying? And by the way, I'd love you to comment a little bit if you had an opportunity on the dignity and beauty and poise of Ahmaud Arbery's mother throughout all this.
She really showed grace during the entirety of this trial. It was really tough, especially given the political climate and everything else going on. And as we had noted earlier, the Rittenhouse trial was going on at the same time. Something I would like to point out is when I spoke earlier about the Rittenhouse trial, we talked about a little bit how the criminal legal system is imperfect. And in some cases, there is some modicum of justice that can be served, especially to the victim's family. And in this case, the Arbery family has gotten some sense of closure here, that there has been a conviction delivered against the individual who killed Ahmaud Arbery. And so in that sense, that this case has gotten it right. But I would say that it is just one case. And hopefully it is one that will show us that it's possible for our criminal legal system to get it right, and that we still have such a long way to go, but that we have made some progress.
Yeah, fair enough. And Mike, we've had Laquan McDonald case, conviction of a cop. We've had George Floyd, conviction of a cop. I mean, this isn't a singular case by far. There have been many convictions. But again, to Jenvin's point from before, even though those other cases were big cases, this one struck, these two cases, Rittenhouse and Mr. Arbery, struck a chord in the community with regard to race relations. I was very heartened to hear The Reverend Al also say that white people aren't all white supremacists. This is the kind of balance I think needs to be said in the messaging and the narrative, so that people don't feel that they're always on the defensive, because the fact of the matter is this was shockingly an all-white juror minus one juror that came back with this conviction, which is problematic in my mind to begin with. But what are your thoughts on his comments?
I thought his comments were very motivating, quite frankly. They really put things into context, and they were very dignified in the fact that it said I got from that is we shouldn't give up hope in our justice system. People are working in our justice system. It may not be perfect. It may make its mistakes, but it's a system we have in place, and we can only be active in respecting it and looking to improve it, not just sitting around criticizing it with no answers to our criticisms of it.
Yeah, and a lot of times, like you pointed out before, Mike, and I can tell you that firsthand, when they don't have a full set of factual knowledge and legal issues that are at play with these cases, I know most of the prosecutors I've worked with have tried to get it right, and again, fallible people we are. Anyway, Latonia Hines from Cobb County District Attorney's Office, who actually has been a guest often on the Law and Crime Network, released a statement. Let's take a listen to a little bit of Latonia's statement.
First and foremost, we want you to know that from the moment this case came to our office, it was our foremost goal to ensure that we got justice for Ahmaud Arbery's family. And in particular, we are so very proud and thankful for the confidence that the family has given to us. We admire and commend the courage, the steadfastness, and the strength of Miss Wanda Cooper-Jones, Ahmaud's mother, and Mr. Marcus Arbery Sr., the father of Ahmaud, in seeking this justice during this process. It has been a long road, and we are so happy that we're able to be here at this end of this road. We'd like to also say thank you, and we commend the courage and bravery of this jury to say that what happened on February 23rd, 2020 to Ahmaud Arbery, the hunting and killing of Ahmaud Arbery, it was not only morally wrong, but legally wrong. And we are thankful for that. Ahmaud's death has significant changes in this community, and in our state and in this nation. With the passing of Georgia's first ever hate crime bill and the changing of Georgia's antiquated citizens arrest law. We want to thank this community for the support that it has given to the family and to us and the community at large.
Mike Koribanics, again, always talking about that family, right? And how dignified they were and faith-based, that had hope throughout all of it. Let's not forget the prosecutor here, dogged, tenacious, really capable prosecutor who put this case on. And the fact that this case stands for not just justice to the extent that justice can be given to Ahmaud Arbery and his family and his community, but also a significant change in laws. First hate crimes bill, that's kind of shocking to hear. I didn't know that. And the change in the citizens arrest law. This case is going to have a profound effect legally, well beyond the sentencing of these defendants. Thoughts?
I absolutely agree with you, Bob, because it also came through in a time, Bob, where, we're in a pandemic. People had the opportunity to spend time and watch a trial on Law and Crime to see what was going on with the case. I think a lot of people have been opened up to during this period of time during the pandemic to watching these major cases that came across at the same time as well, and are starting to learn about a branch of government, the judiciary, the legal enforcement, all those parts of the government that they really never paid attention to unless they or someone in their family got in trouble. So I thought this was interesting in the process, and I think it will help speed the process up of correcting a lot of misdeeds that have occurred.
Gentlemen, from a civil rights point of view here, there will be a federal civil rights prosecution. They have been indicted on that. What do you think the math is there? Do the feds wait to see what the sentencing is? I mean, we know they're going to at least be life sentences. Do they go forward with that case?
I think that it's important symbolically for them to go forward with the case to show that there really is going to be some sort of accountability here. And what I would like to point out also about how significant this is that this prosecution almost didn't happen, and that there were activists and grassroots organizers on the ground who called for this prosecution, who called for justice and accountability for weeks on end until there was finally a capable prosecutor who was willing to take this, on. And so it almost didn't happen. But what we see here is that when the community speaks up and says, we want accountability, that our elected officials, if they hear them and they answer appropriately, there can be accountability. And so I think that that's where we're at. And I think that there is going to be accountability because the community is demanding for it.
Right. Yeah. Hopefully, when the community demands for it, it would be a reasonable demand, because prosecutors are not supposed to be swayed by the court of public opinion, but rather facts and law. But I get your point. This case would not have been in a courtroom had it not been for the community involvement. I'm convinced of that. Anyway, the lead prosecutor did a great job in the case. Wasn't backing down to the defense attorneys, had a lot to work through, including, it's very difficult when you're doing a murder case. Also making sure that, excuse me for a moment. Well, I'm being told that actually we're going to go through a break, but it's very difficult for prosecutors to be able to work with the victim's family, who are obviously suffering as well. So she did a great job. Congrats to the prosecutor. All right, let's take that quick break right now. We'll be back on the other end. Jenvin, we're going to have to sign you off because we have another special segment we're going to be doing. But I want to thank you so much for staying late, and I look forward to having you back on the show. We'll be right back. All right, welcome back to Law and Crimes for the Record. My name is Bob Bianchi. You'll be taking it at 3 o'clock. So we are now back in session in New Hampshire versus William Argy, 48 years old, accused of murdering his wife of 13 years. Date of incident was April of 2019. He's charged with both first and second degree murders and falsifying evidence. The prosecution says the motive was a $400,000 insurance policy. So far, the prosecution's put on an opening statement and is now putting on its witnesses, one of which is Elisa Logman, who's on the witness stand right now. Let's go live to court.
And with respect to the still photos, I'm showing you 20 through 32 in evidence. And again, you've seen all these still photos before?
Yes. Yes.
With respect to the contents of State's Exhibit 11, that flash drive, the red flash drive, showing you State's Exhibit 35, does this show the digital files that's contained on that flash drive?
Yes, it does.
And what do each one of those lines of data with a symbol on the left, the orange snow security film, what does that indicate?
It's a video. It's approximately an hour of each video surveillance.
So each one of those individual files contains about an hour of video surveillance?
Correct.
And did you review each one of these video files?
Yes, I did.
So let's go over the files that you reviewed. And let's start with State's Exhibit 20. This is a still photo that the jurors are going to see in a few minutes later on. But were you asked to focus your attention on anywhere in particular when reviewing the video?
Yes, the top right section is the driveway and yard that I was watching.
So I'm pointing a laser point at this area right here, and it appears to be a driveway area from what you saw?
Correct.
With respect to observed activity in that area where you focused your attention on, State's Exhibit 34, does that summarize the observed activity in that area where you focused your attention?
Yes, it does.
Actually, Judge, can I bring the board over so the jurors can take a look at that? The chart might be difficult for the jurors to see, and plus I'm going to be showing some videos. Can I bring that?
The whiteboard?
Yeah.
Of course, yeah. I'm sorry, I didn't know what you were pointing at.
Okay, so prosecution getting its case together, trying to get exhibits as their witnesses coming onto the stand, trying to develop a theme that this was the motive of trying to take $400,000 of insurance money. Some of the evidence that will come out during this case is that the victim, the wife, Maureen, had contacted the police at a certain point in time just before the murder, concerned about her safety, wanting to make sure the telephone lines were working with respect to that, as well as other witnesses who are going to come on the witness stand and indicate that there was problems within the relationship, not to mention an individual who may testify for the government that the defendant tried to get him to pay the person to kill his wife, and that person rebuked that. We'll see if those people get called to the witness stand. Let's go back 5 forward.
And we'll play about a minute and a half from this particular portion. Where will activity be occurring on this portion of video that we're going to be playing?
The upper right corner.
And will a motor vehicle ultimately be seen coming from that area and driving towards the left in the video?
Yes, correct.
So the vehicle will be coming on that roadway towards me.
Correct.
So we can play that now. As we're playing this video, you can see the timer continuing. This date and timestamp, that was on the video when you observed it, correct?
Correct.
That wasn't something that you added later on?
No, sir.
And again, it's the area that we're focusing on where I have the laser pointer pointed to.
That was a question.
Oh, I'm sorry, correct. I'm sorry.
Okay. And as we're watching the video, was there any audio with the video?
No, there wasn't.
So there was no sound that accompanied the video?
No.
We've seen activity in that area right now, a vehicle.
Yes.
So returning to State's Exhibit 20, is this a still photograph taken from the video that we just played?
Yes, it is.
And contained in that white circle, is that the vehicle that we saw our activity on?
Apparently, yeah.
So now let's continue to the stamp time of about 7:36 a.m. again on April 3rd. And we will play about a minute and a half. And will there again be activity, bless you, Judge, in that area that we focused our attention on before?
Yes.
Is it going to be a vehicle like we just saw or something different this time?
This is going to be 3 people going to the end for a school bus and then 1 person returning.
And with respect to the school bus, will it be coming from the left as we saw with that cargo in the previous one?
I believe so, yes.
Oops, I'm sorry. My colleague played that. And can we see some pedestrian activity in that corner area?
Yes.
And with respect where the bus comes from, that's from this area towards the right?
Correct.
And will the bus be appearing in a few seconds?
Correct.
next slide shows State's Exhibit 21 in evidence. Is this a still photograph from the video that we just played?
Yes, it is.
And it may be hard to see, but we have circled in white. Is that some of the pedestrian activity that we saw
Yes,
in the
it
video
is.
just played? Let's continue with a timestamp time. Now we're at about 8:19 a.m. on April 3rd. And we're going to play about 40 seconds of this video. And where again was activity going to be occurring from?
It's going to be in the upper right corner.
And will that be more pedestrian activity rather than vehicular activity?
No, it'll be vehicular activity.
My colleague, please. So we see a pedestrian.
Oh, correct.
So you were mistaken before?
I am. I'm sorry.
That's
I apologize.
And as we continue with that, what appears to be the same figure, head back the other way?
Correct.
So we ended here at about 8:19:40. The next slide is State's Exhibit 22. Is this another still photograph taken from the video that we just played?
Yes, it is.
And so again, we left off at about 8:19:40. The next slide starts at 8:20:20, a few seconds afterwards. And again, do we want to focus on the upper right-hand corner for the activity that we'll be observing from this
Yes.
video?
Yes, sir.
And here it's about 20 seconds. And this time it will be a vehicle?
Correct.
And will it be heading towards the left, towards us?
Yes, it will.
Or towards my area?
Correct.
If my colleague would play that 20 seconds, please. The next slide is State's Exhibit 23. Again, is this a still photo from the video that we just played?
Yes, it is.
Does this appear to be a different vehicle than the video that we saw early on, which showed an SUV type of vehicle heading in this direction?
It's a different vehicle, correct?
So the next video that we're going to play is about 6 hours later. But even though we're going to be playing 6 hours later, did you review that approximately 6 hours of video between this time, about 8:20 a.m., and the time we'll be viewing next, which is about 4:37 p.m.?
Yes, I did.
And aside from vehicular traffic on that road, regular vehicular traffic, what general activity did you observe in that area of focus, the upper right-hand corner, in that roughly 6-hour period that you reviewed?
During that time, I didn't see any activity.
All right, prosecutor building a case, block by block. We'll see if it's enough. Told in the defense that the opening statement was that this was a suicide, not a murder, that this was done self-inflicted wounds with a bed sheet around a pole in order to, and that is what the strangulation was. Very interesting. We'll see what happens as we go down this case a little bit further. We'll be right back. New Hampshire versus William R.G., 48 years old, murdered his wife for 13 years. Now, the prosecution says the motive here was an insurance policy of $400,000, but we are learning that in opening statements that the defense said he didn't kill his wife, that she killed herself. The defendant found her in bed with a sheet around her neck tied to a bedpost. The attorneys say he untied it so that the children wouldn't see. So medical examiner testimony is going to be very key in this case. Thank you, Kathy Russell, for that update. When we get that live video from the opening statements, we certainly will share that with you. Let's go back live to court with one of the prosecution's witnesses.
Arriving from the left-hand side as we did in the video that we saw a few minutes previously?
Yes.
And so I'll ask my colleague to play this. And again, this is about 4.5 minutes long. And we've been talking about, we see pedestrian traffic, we see that right now in the upper right-hand corner. Can you identify any of those people?
No, I can't.
We have about a minute and a half of video remaining. Does that sound about right?
Yes.
Talk that a school bus is going to be coming into view from the left. Does that appear in a few seconds?
Yes, it does.
So we just played the video. I'll now turn to State's Exhibit 27. Is this another still shot of the video that we just played?
Yes, it is.
So this video was ended at about 7:37 a.m. We're going to continue now about half an hour later, 8:12 a.m., again on April 4th. We're going to be playing about 25 seconds. And again, the activity that we're focusing on is at this upper right-hand corner.
Yes, it is.
My colleague can play this roughly 25-second video. vehicle that appears to be exiting that driveway area, is it going to be heading towards us, going towards the left on the road?
Yes, it is.
The next exhibit is State's Exhibit 28, and is this another still of the video that we just played?
Yes, it is.
And contained within that white circle, is that the vehicle that left that area where we focused on, that driveway area on the upper right-hand corner?
Yes, it is.
So we have here a time of approximately 8:12 a.m. according to the date and timestamp. We're going to move forward about half an hour to 8:41 a.m. Even though we're moving forward a half an hour, you reviewed the entirety of the video?
Yes, I did.
In that half-hour period?
Correct.
Did you observe any activity in that area where we've been focusing on that upper right-hand corner area in
No, I
between the period of between 8:12 a.m. and what we're going to be viewing now, 8:41 a.m.?
No, I didn't.
Did you see any vehicles, any other vehicles enter or leave that area in that roughly half an hour time span?
No, I did not.
So here we're going to be playing about 15 seconds. In the last video, we saw a pickup truck coming or going to the left in the video. And this portion that we're going to be playing, does it come from that left area?
Yes, it does.
And if my colleague can play that again, it's only about 15 seconds or so. And is that truck?
It is.
Next exhibit is State's Exhibit 29. Again, a still of the video that we just played.
Yes, it is.
So we have here a time of approximately 8:41 a.m. So the next slide is for a time of about 2:02 p.m. that same day. So it's about 5 hours and 20 minutes later. Did you review again the entirety of that approximately 5.5 hour time period between the video that we just viewed and the clip that we're going to be viewing now at about 2:02 p.m.?
Yes, I did.
Did you observe any activity in that upper right-hand area where we've been focusing our attentions on between approximately 8:41 a.m. and 2:02 p.m.?
No, I didn't.
And more specifically, did you see any vehicles enter or leave this area
No,
during
I
that
didn't.
approximately 5.5 hour time period?
No, I did not.
So now we'll play the video. Here it's about 30 seconds, and we're going to have some vehicular activity in that area we've been focusing on.
Yes.
So if my colleague can play again, it's about 30 seconds. And that vehicle leaving the driveway area, is it again going to go towards the left, towards me on the video?
Yes, it will.
So the next exhibit is State's Exhibit 30. This is a still photo from the video that we just saw.
Yes, it is.
So the two previous videos before this one showed a pickup truck. Does this vehicle appear to be different than the pickup truck we saw in the two previous videos?
Yes, it is.
So here it's about 2:03 p.m. date stamp time. We're going to move forward about 8 minutes to 2:11 p.m. Did the next activity that you observed involve a van?
Yes, it did.
And with respect to that van, is it going to be pretty difficult to see, but coming from this area to the right rather than coming from this area to the left?
Yes, it will.
Okay, we're going to be playing about 20 seconds of video here. It's brief, and again, it may be hard to see, but the van will be coming from this general area. Yes?
Correct.
My colleague can play the video now, please. And do we see the van right now?
Yes.
And do we see it in that area we've been focusing on?
Yes, it does.
So it's a van that appears to be using the driveway to back up and change direction. Is that fair to say?
Correct.
And the next exhibit is State's Exhibit 31. This is a still photograph from that video that we just played of that van changing direction.
Correct.
Flashing. So we're going to play the last video.
All right, testimony of the state's witness. Mike, I want to go to you with this news that we have in the opening statements, which we're hoping to get shortly so we can show it, that the defense is arguing that the sheet was wrapped around her neck and tied to a bedpost. It's going to be a medical examiner case if you start getting to that. I've actually had a case similar to this, so it'll be very interesting. My suspicion is going to be that the state's medical examiner is going to say you would pass out before you would actually asphyxiate or choke yourself unless you were in a hanging position. Don't know if that's what's going to happen here, but that's the defense. What are your thoughts?
It's always a very difficult defense because regardless, you're going to have, once again, it's the battle of the experts more so than the battle of the facts leading up to the incident. So it'll be very interesting to see what the medical examiners have to say and where this leads. It is difficult. It's always a tough road to travel when you're trying to say the person hung themselves and you really can't have any sort of backup of how she got untied and things of that nature. And it's going to be a pretty difficult road to travel, but we have to see what the science says on it.
Yeah, that'd be a lot of where the body was positioned and when it was actually found. Was it on the bed? Was it off the bed? I mean, so many factors like that, Mike. But I guess the defense trying to bring the reasonable doubt to try to combat the prosecutor's argument about the motive of the $400,000. But if in fact it is true based on articles we read and whether or not the witness testifies or not, that he actually tried to hire somebody to kill her, I think that that's pretty much game over at that point in time. But that still doesn't mean the person could commit suicide. But that's going to be some really significant motive evidence for the prosecutor.
Well, absolutely, because you have someone now who's not part of the, for lack of a better term, part of the script of this defendant's life, who will now just verify that not only was he thinking about it, he actually talked to me about it to see if I could help him carry it out. And I think that's devastating evidence when you have some circumstances such as, even if you're claiming that she hung herself, the very fact now you have this evidence is going to have the jury thinking, wait a minute, let's look at this evidence very closely.
Yeah, and do you think that the context of, and I just asked, like the Me Too movement and our emphasis that we now place on domestic violence, to my point before, today's domestic violence is tomorrow's murder case, will weigh on the jury more favorably to the prosecution than it may have 10 years ago?
Well, I believe it is, Bob, and I think it's just we're all much more aware today than we were 10 years ago about how common mental health issues are, how they are many times well hidden within the family structure, especially. I mean, we deal in New Jersey where we have some very strict domestic violence laws, and it's been a very hot topic in this state for many years. And I think that what we're going through is really an evolution as to facts being better known, that we're not all well mentally, even though someone may appear to be, and there's a lot of contributing factors. That's the interesting thing that kind of testimony would provide.
Yeah, excellent analysis, Mike. Okay, we're going to take a quick break here on the Law and Crime Network. We'll be right back. Please stay with us. New Hampshire versus William Argy. The defense is now cross-examining the state's witness. Let's go back live to court.
Any redirect?
No, may this witness be released?
Any objections? Okay. Okay. Ma'am, you can step down, you can stay, or leave as you choose. Thank you.
All right, Mike, that was a pretty quick cross-examination, which indicates that this must just be foundational evidence. You know, we have to explain to our audience, Mike, that sometimes it can be a little laborious, but you got to introduce the evidence a certain way in order to tee it up for analysis, either for experts or other witnesses down the road. What do you think?
Yeah, I think a lot of what we're seeing here is foundational. Like I said earlier, Bob, is this defense attorney really isn't cross-examining every witness, because I don't think any witness really is doing anything right now other than laying the foundation, as you pointed out, to later introduce other evidence that will be more effective against the defense. So right now, it's really just preparation work for the prosecution, as I see it.
You know, Mike, at the Law and Crime Network, we have a lot of people here are lawyers that watch the show and aspiring lawyers and just true crime aficionados. We're getting into the nitty gritty of trial tactics here, but we have ourselves seen where if you stand well, stand still. That was the big line Judge DiStefano told me in a murder case. And I trained it ever since. But sometimes a lawyer gets up there when they didn't really have anything to say and then opens the door to something that actually hurts their client. So it's a smart move sometimes that less sometimes can be more.
Well, Bob, I always go by the adage, if my question can't improve the situation, what's the point of asking it?
Well, we've seen a couple that have felt the compulsion to get up and hear themselves talk, though, right, Mike?
Oh, we've seen it many times throughout our career, and many times when that occurs, it usually works to our benefit if you're on the opposing side.
Yeah. So far, though, Mike, this case I think is going to kind of go in kind of quick. It seems to me the issues are going to be pretty much squarely, in my mind, based on what we've been told the opening statements are. It's just the cause and manner of death. That's where the issue is here. What do you think?
I tend to agree with you, especially when they, in their opening statements, are saying this is not a question of an unsolved murder. This is a question of a suicide, and the state's not going to meet its burden. It'll be very interesting to see what the medical experts have to say here.
And Mike, what do you think the defense is given a medical report, obviously, to the prosecution, and will that expert then try to opine on that report, or do you think it's a scenario where the defense goes and then that medical expert for the state, the forensic pathologist, comes back in rebuttal?
I would think that they would have to have given an expert report prior to the beginning of their testimony. I think if they see it coming, and now that the defense has opened up to it and told the jury, basically, we've made a promise of what we're going to produce in evidence, that they're going to try to, through the prosecution's expert, get rid of any sort of reasonable doubt that they're trying to create by the defense expert.
You know, Mike, we were listening early on in the show today about Rittenhouse's attorney and talking about how when he first was listening to the case, he thought the guy used a colorful term, not very positive towards him. But when he started looking into the case and seeing that it was more of a narrative than the facts, I'm not getting back into Rittenhouse, but I want to talk about how important it is to, like, I've never tried a case that I did not believe fully and completely confidently in either the prosecution I was delivering or the defense I was giving. How much emotionality goes into that with most lawyers, do you think? Because haven't you found that most really genuinely believe in the side, even though you completely disagree with the other side?
Oh, Bob, it happens. It's a disease for us defense attorneys, especially, is if you're not, regardless of what the facts are, if your client exercises their right to a trial, you have to give your all to it. You have to delve into the facts. You have to look at the videos over and over again, and you have to create whatever position you need on behalf of your client. That's why I always say, the truth as it's proven in court is different than the truth people believe on the street.
You know, Mike, real quick, it reminds me of a case I first took on when I left the prosecutor's office, and the guy was dead on paper, witness statements, the whole thing. Turns out, I won't go through the whole story. There was a videotape that was withheld from me, and the videotape showed that my client was not the shooter. And my father, the lawyer, said, you learn the lesson. Once you start judging people as a defense lawyer, innocent people go to jail. I got 10 seconds, Mike. What do you think?
Well, first of all, your father was a great director of mine and mentor to me, so I agree with it. And whatever he says, always, I tried my first civil case with your father.
Okay. All right, Mike. Well, I know your dad was a great trial attorney, too. I really greatly appreciate the compliment. We're going to take a quick break here at the Law and Crime Network. Stay with us. We'll be right back.
And you're watching Law and Crime.
All right, New Hampshire versus William Argy, 48 years old, the murder of his wife. He's being accused of 13 years, occurring in April of 2019. He's charged with first and second degree murder. by way of strangulation is the state's argument, and it was over a $400,000 insurance policy. But in opening statements today, the defense is saying it was a suicide with a bed sheet wrapped around the neck and a bedpost. So that will be the disputed medical evidence testimony that we'll hear in the case. Right now, the state has on the witness stand Matthew Anderson, who is from the New Hampshire State Police investigating the case. Let's go live to court.
By other investigators.
Several dozen.
Were the majority of those interviews recorded, either audio recorded, video recorded, or both?
Yes, both.
And is that again pursuant to the standard procedure?
Yes.
If somebody agrees to recording?
Correct.
Did virtually all the dozens of people who were asked for interviews as part of the investigation agree to be interviewed by investigators?
Yes.
Did you yourself personally interview any witnesses?
Yes.
Who do you recall conducting recorded interviews with?
David Lang, Lisa Lang, Ray Karen, and Dan Larochelle.
Was one of the people who investigators sought to locate early on in the investigation into Maureen Argy's death her husband, the defendant, William Argy?
Yes.
Were investigators able to locate the defendant immediately after police found his wife's dead body inside their home in Londonderry?
No.
Were attempts made to try to contact and locate the defendant, Mr. Argy, after the police found his wife's dead body inside their home?
Yes.
What efforts were made to try to contact and locate the defendant after his wife's dead body was found in the house?
We tried calling his phone. We tried calling other police departments, see if they had any recent contact with him. We pulled toll records from the surrounding states to see if we could get a direction of travel or see where he was going.
And with respect to toll records, that's a toll booth that a car goes by and the license plate may have been recorded?
Correct.
Were those initial efforts to contact or locate the defendant successful?
No.
Ultimately, was law enforcement able to locate the defendant?
Yes.
When and where was that?
April 5th, 2019 at the Foxwoods Casino.
And that's in Connecticut?
Correct.
What generally was some of the other various tasks that you personally conducted as part of the investigation into Ms. Argy's death? You talked about how you conducted witness interviews. What else did you personally do?
I conducted a neighborhood canvass of the surrounding area, 118 West Road, and I also collected surveillance footage.
And with respect to canvass, if you can tell the jurors what that entails generally.
A neighborhood canvass is when we kind of go around the area where the scene is, so 118 West Road. We go door to door, we talk to all the neighbors or anyone who might have pertinent information, ask them if they know the family, if they know anyone that was involved or what happened, and we also ask them if they have any surveillance footage or anything like that that might be helpful.
In the course of conducting that canvass, was surveillance footage obtained from 116 West Road in Londonderry?
Yes.
Showing you a copy of State's Exhibit 11. Again, it's a nondescript flash drive. But you reviewed this and placed your initials and dated it, correct?
Yes.
And is this a copy of the surveillance footage that was obtained from 116 West Road?
Yes.
On the screen, I'm showing you State's Exhibit 35. It may be difficult to see, but you've seen this photograph before, right?
Yes.
Does this list of media files contained in that original footage that was obtained from 116 West Road?
Yes.
We're going to get into the actual contents of the surveillance obtained in a moment, but if we can start with the area that's depicted in the surveillance footage. And I want to show you State's Exhibit 60. And what is depicted in this photograph?
It's a aerial photo of 118 West Road, and 116 West Road on the left-hand side of that road.
And with respect to 118 West Road, is that the area that I'm circling with the laser pointer?
Yes.
And where is 116 West Road?
It's directly above it. With the yellow
circling the correct location?
Yep.
You've seen actual surveillance footage that was recovered from 116 West Road, is that correct?
Yes.
You have in this photograph area in yellow. What does that represent?
That shows where the surveillance footage was pointing to.
So the open-faced area is kind of where the video would show?
Yes.
showing your State's Exhibit 20. Does this appear to be a still photograph taken from the video recovered from 116 West Road?
Yes.
And if we can start first with the numbers and letters on the upper left-hand corner. What do those numbers and letters represent that I'm circling with the laser pointer?
That's the time and date stamp from the surveillance footage.
Was that information something that was embedded in the surveillance footage when it was recovered from 116 West Road, or something that was added by investigators or someone else after it was recovered?
It was embedded.
Now, the video shows a vehicle in the upper left, and it's circled in white. The circle, unlike the embedded time and date stamp, was this circle added after the fact?
Yes.
And the clock, I think the jurors saw that with the previous witness, but that records time in military time?
Correct.
So the 7 o'clock that was seen here is 7 a.m. and 7 p.m. would be 1900?
Correct.
Upon receipt of the surveillance footage from 116 West Road, was it determined that this embedded time stamp was slightly off?
Yes.
And how was that determined, that the time was off?
It was compared to when Londonderry Police Department showed up on scene. It was seen in that, and it compared with the time date stamp that they called off there and other similar events like that.
And with respect to events like police arriving at a certain scene at a certain time, is that typically documented by police departments?
Correct, through dispatch.
And with respect to the time difference, what was the time difference determined to be about?
It was approximately 41 minutes slow.
And so, looking at this exhibit again, it shows a time of 7 a.m. on Wednesday, April 3rd. So the more accurate time of when the recorded events actually occurred would be closer to 7:41 a.m.?
Correct.
So we next have State's Exhibit 33. Is that time correlation depicted in this exhibit?
Correct.
So again, we have the time on the surveillance video, and we have the 41-minute adjusted time that's in the red circle. I mean, in the red rectangle. Yes?
Yes.
Did the surveillance footage recovered from 116 West Road have audio as well as visual?
No, just visual.
And is the camera that's recording stationary, or does it pan from left to right or up and down?
It was just stationary.
With respect to what's depicted on this still, we have a house with a white porch and railing. What house is this that I'm turning my laser pointer on?
That is 116 West Road in Londonderry.
And what is the roadway that the vehicle circled in white is on?
That's West Road in Londonderry.
And what, if any, portions of 118 West Road, when Ms. Argy's body was found, is in the field of view for this surveillance footage from 116 West Road?
Part of the driveway and part of the front yard of 118 West Road.
I'll give you a laser pointer, and if you could point the areas of 118 West Road that's seen on this surveillance footage.
So approximately right there in between the two trucks.
That driveway, is that the only vehicle pathway into and out of 118 West Road?
Yes.
As part of the investigation, was it determined whether and what kind of motor vehicles Maureen Argy and William Argy drove?
Yes.
And what vehicles was it determined that each drove?
Maureen drove a 2017 Nissan Murano color blue, and William Argy drove a 2018 Ford F-150 pickup truck color gray.
Staying on this exhibit, State's Exhibit 33, with respect to Maureen Argy's believed vehicle, is the vehicle circled in this still consistent with that type of vehicle?
Yes.
With respect to the defendant William Argy's truck, I'm showing you State's Exhibit 23. Is the vehicle circled in this exhibit consistent in appearance to the truck believed to be owned by Mr. Argy?
Yes.
I want to go back to a still that the jurors saw from the last witness, which is State's Exhibit 24. may be difficult to see, but in the top right, we have a truck circled in white.
Yes.
And does that appear consistent with the truck that we just saw in the previous still?
Yes.
And this again is the driveway area into 118 West Road?
Correct.
And with respect to the time and date here, it has a time and date of 4:37 p.m. on April 3rd. But if we correct that with the additional 41 minutes, that would be about 5:18 p.m. on April 3rd. Is that correct?
Correct.
The jurors heard testimony from a Thomas Griffin, who at the time worked at Let's Play Music in Manchester. About how long of a drive is it time-wise from Let's Play Music in Manchester to 118 West Road in Londonderry?
Approximately 14 minutes.
And again, the corrected time that we have this vehicle pictured here is about 5:14 p.m.
Correct.
Also, as part of the investigation in this case, we asked to look up certain telephone numbers and area codes.
Yes.
And how did you go about doing that?
Through internet searches and then actually calling those numbers and confirming that that number was still in place back in 2019.
So with the last slides, I want to go over portions of State's Exhibit 43 in evidence, which is a communication chart for the cell phones with the numbers corresponding to Maureen RG and William RG. I want to ask you about certain area codes and numbers. And first, we have area code 339. What state does that correspond to?
Massachusetts.
And that's reflected in the exhibit?
Correct.
And you actually verified the...
All right, Matthew Anderson, New Hampshire State Police, again, laying more foundational work down, getting into timelines and distances in order to be able to prove its case as it moves forward with other witnesses where this information will become relevant. Not only is the most exciting testimony that we hear or when we try in a case, but very, very crucial and important for the prosecutor to do nevertheless. So we're going to take a quick break here on the Law and Crime Network. We'll be back with more on the other end. Please stay with us. All right, Matthew Anderson from the New Hampshire State Police on the witness stand for the prosecution. Let's go back live to court.
Next are telephone numbers 434-5335, 877-529-4357.
Sorry, could you repeat that number again?
Sure. 603-434-5335.
It's Solomon Law Firm.
877-529-4357.
Solomon Law Firm.
And we talked about Solomon Law Firm before. These appear to be different numbers for the same Solomon Law Firm.
Correct.
And the last on this particular page is 603-242-1503.
ICE Legal Attorneys.
And we'll go on to the last slide that I'll ask you about. And again, I'll ask you about area codes and numbers. Let's start with area code 443.
Maryland.
Area code 920.
Wisconsin.
And area code 785.
Kansas.
Telephone number 800-950-5114.
City card.
603-624-3700.
10 and 10.
And what is 10 and 10?
It's a law firm.
Next, this is from April 3rd, 8:53 a.m., 413-273-5000.
MGM Springfield.
And what is MGM Springfield?
It's a casino in Massachusetts.
And this shows an outgoing call of about 4 minutes, is that correct?
Correct.
And this again is for April 3rd?
Correct.
What day again was Ms. RG's body found by the police?
April 4th.
The next day?
Correct.
You Turning to telephone numbers, the next one is 603-552-1400.
Elliott Primary Care in Londonderry.
And then 603-552-5022.
Gould and Gould.
And what is Gould and Gould?
It's a law firm.
Next is 888-224-1059.
Ford Motor Credit.
And lastly, we have 603-434-9910.
Apple Tree Title and Closing.
Thank you for a moment. I have no further questions. Thank you.
Attorney Cross.
Good afternoon.
Trooper Anderson, I just want to ask you some more questions about what Major Crimes Unit is all about. You said there's about 20 troopers in the division?
Correct.
And they're a specialty division?
Correct.
Kind of like the elite of the elite?
You have to go through a process of getting accepted into the unit, yes.
But you consider yourself the best of the investigators in terms of investigating homicide?
I think that depends on people's opinion.
What's your opinion?
I think we're just an investigative body in New Hampshire.
And your specialty is homicide?
Correct.
And when a homicide happens, somebody is a lead investigator.
Correct.
You weren't the lead investigator.
I was not.
Have you ever been a lead investigator?
I have on smaller cases, correct.
Okay. So one of the jobs of the lead investigator is to figure out who else is going to be involved on the case.
Correct.
And the lead investigator in this case was a gentleman by the name of Justin Rowe.
Correct.
And another job for the lead investigator is to keep the team informed about the new information that's coming in.
Correct.
Because new information may lead to more productive investigation afterwards.
Correct.
And it's fair to say that one of the things that happens that the team wait for is the results of the autopsy.
It depends. I mean, depends on what you're looking for.
Well, you sometimes want to know what cause and manner of death is, right?
Correct.
Cause and manner of death will indicate to you whether it was A, a homicide, correct?
Correct.
B, how it happened.
Correct. Manner of death.
Whether it was a knife wound or a bullet wound.
Correct.
Correct? And it's fair to say that after the autopsy, it was still unknown as to the cause and manner of death.
Correct.
Thank you.
Any redirect?
No. May this witness be released?
Any objection?
No, Your Honor. Oh, wait, yes. I would like to have him available for potential impeachment or another witness.
Okay. So, Trooper Anderson, you are excused for today, but you're subject to recall.
Thank you, Your Honor.
Thank you.
That's where you go with a surgical cross-examination there, Mr. Koribanics. We talked about it before. Medical evidence as to whether this is a homicide or suicide is what the issue in this case is. She kind of tried to get out there that you were investigating, even though you didn't know the cause of manner of death. There is nothing unusual with that, but it's what the jury knows as opposed to what's said in court. But most importantly, they didn't know after the autopsy what the cause and manner of death is. What did you think about that? Because all of a sudden, maybe they got a theory of the case, and we all know that prosecutors and cops and medical examiners often discuss things together.
Well, I think she's made a very good point, Bob, and I think this was her cross was even more effective since she really didn't waste time on other witnesses who had anything to offer. But I think she's laid the foundation for the defense is that they really don't know what caused her death and can prove it beyond a reasonable doubt. And they just went on their own to decide how to fit the script since they had no science to back up the finding. But as you pointed out, Bob, based on your experience, because you're a courtroom lawyer, not a conference room lawyer, you're in the courtroom, is that you really can't stop an investigation because you're waiting for what the scientists are going to do. By scientists, I mean medical examiner, and you have to keep progressing. But I think she may have, gained a little momentum here.
Yeah, but they're taking a 10-minute recess, Mike. I want to break down some of those points for you for our audience. When you go out there, she talked about data management. Data management is the biggest problem you have in the beginning of a case, because you have multiple cops doing things, canvassing, speaking to witnesses, doing a social history, a family history, trying to see who's got motives or not. And a lot of times, all the information isn't funneling in. It's a really daunting process. And when one investigator may be asking questions of a witness, they don't know that another investigator got very valuable information that would have been relevant to the witness interview that's being done by investigator B. That's the first point that we have here. And I have to say, and I'm just being straightforward, candid, and honest, as a prosecutor, there were many times I had a lot of problems with the medical examiner's office because they were calling things, believe it or not, it may sound counterintuitive to what the public thinks, medical events and accidents and suicides that were in truth later determined to be homicide because we pressed the issue with them and people are serving life sentences in prison. So it's not like you see on TV. A lot of these things are very interpretive because they really can't figure out one way or the other. And sometimes influences can make them move in a certain direction when it's not necessarily accurate. We talked all in the last segment about we're all flawed human beings. That is a reality of the real world of trial work.
Absolutely. And Bob, the thing is, we depend on facts and gathering facts. And you could gather a bunch of facts that you think fit the story or the investigation, yet by the 10th day of your investigation, a new fact could come in that you weren't aware of and really put all the old things that you thought were facts, really outdate them and not make them any more relevant. That's why the most important investigation that will seek justice is not one that reacts to get this done as quick as possible, but one that actually goes through the natural rhythm of an investigation and really has no preconceived notions, just looks at the facts.
Yeah, and prosecutors and police, Mike, who are willing to pivot from their original conclusions when they see something to the contrary. All right, Mike Koribanics, certified criminal trial lawyer, law and crime legal analyst. Thank you so much, as always, for your commentary. We're going to take a quick break. We'll be right back. All right, New Hampshire versus William Argy, 48 years old, on trial for the murder of his wife of 13 years in April of 2019. The death was by strangulation. That's at least the government's offer of what the death is in this particular case. They say it was because there was a $400,000 insurance policy you wanted to get. The defense countering that it was a suicide, that this bed sheet was wrapped around her neck and a bedpost, and that the defendant is not guilty of the crime. Testifying today in this case was a defendant's friend that he had, Argy had tried to get him to want to kill his wife and to get him to assist him to kill his wife. Let's take a listen to a little bit of that direct examination, because that will obviously be hugely crucial information if the jury believes the credibility of that witness.
For about how long had the defendant expressed dissatisfaction with his marriage to Maureen to you? About
3, 4, 5 years.
Did the defendant also, in conversations with you, talk about killing his wife, Maureen?
He did.
And about when did those conversations occur in relation to the intervention in March of 2018?
In the year or two prior to that.
What did the defendant say to you in those conversations that you remember, killing his wife?
He basically, part of the conversation was, all right, Bill, you're gonna go down to South. Maureen's not gonna go. She's gonna take half of everything. So you're gonna make twice as much money, but you're gonna write a check right back to Maureen up here. And he didn't want to hear any of that.
And with respect to killing his wife, what would he say about that?
Again, he said, I'll do it, or I'll hire somebody, or I'll, you know what I mean?
So employment and money issues were reasons the defendant talked to you about killing his wife?
Yeah.
What about the kids? Was the kids also another reason?
He loved his kids. He just, you know, he wanted them. It was like possessions.
What about paying child support for him based on conversations that he had with you?
He didn't. He wouldn't do. It was unacceptable to him. It was losing money.
What else do you recall the defendant saying about how he would carry out killing his wife that you remember?
Again, if he didn't do it, he'd hire somebody.
Okay, that's a friend testifying, Mike. Not an actual person he actually asked to participate in it, but indicating that he spoke for 1.5 or 2 years about trying to kill his wife, and that it was all about the money. A pretty damning testimony. In fact, would be case closed if the jury were to believe him alone, in my mind. Of course, we have to wait for that medical evidence to come out, but providing powerful motive to the prosecutor. Again, keeping in mind prosecutors don't need motive, but this witness was a good one. Mike?
It's just an interesting thing. I'd like to see the cross a little more on this, Bob, because I think the big question is going to be is, did you take him seriously? Because if you did, why didn't you contact law enforcement earlier? I think that's going to be the defense's way to create some reasonable doubt about his statement.
Yeah, and Mike, what about, we were talking about offline about the jurors and lawyering, and about using common sense, everyday ordinary experiences, and their knowledge about the way the world works. I mean, it goes within the prism of that juror's experience as to how they're accepting evidence like that. How important is it for the prosecutor to resonate with the jurors on a common sense level about what occurred here?
Well, I think it's very important because I think sometimes, and I sort of am inconsistent with my explanation of this, because beyond a reasonable doubt is a very high legal standard. Yet when you really look at it in the courtroom setting, it's really not beyond any doubt. So I think it's very important for a prosecutor always to rely upon common sense, but always make sure you show how that common sense applies to the law. And that's how you get rid of any doubt with the jury, as opposed to just thinking, I got to make them understand this fact. No, you need to make them understand this fact, if proven, how it applies to the law.
All right, Mike, you talked a little bit about the cross-examination. Want to see where that went. We have a clip on that, so let's go to it.
And after you heard this so-called threat, you didn't call the police?
No.
You didn't walk off the golf course and call Maureen?
No.
You didn't document it in a calendar or notes or something that, hey, my friend just threatened to commit the crime of murder. Didn't do anything like that.
No.
And then at the intervention, by the way, the intervention, was there any trained counselors there?
No, we tried to get one.
And so no one who was there was trained.
No.
And when you say we, who's we?
Me and Maureen.
And where did you attempt to get one?
We called a bunch of social services. Maureen was a social worker. We called the hospital. We called the police department. We called a variety of things to try and get him some services and what our options were.
And what did Maureen say?
I don't think the witness finished answering the question.
Go ahead. I have hard of hearing, so I didn't hear you last part.
Yeah, we really searched for a while to find him, to figure out what this would look like. I've never done an intervention before, but I thought it was important and it needed to be done. So we did it.
Mike Koribanics, you must be prescient in terms of the area of cross-examination you thought they should get into, of course, because you're a great trial lawyer. What did you think in terms of the effectiveness of that piece of what the defense lawyer did there?
Well, I thought it was really effective, Bob, until she went and asked that one or two extra questions where he sort of was like, well, I didn't call this, I didn't do that, but we looked for help for him. So he's actually, I think, helps the state through those last couple of questions, because what he's saying is, I didn't know if he was going to kill her, but I know he was having problems and there was a problem. That's why we wanted to have an intervention. and he's very candid. I've never been through this before. I did the best I could. I think it was not as effective as I thought it was going to be because I didn't anticipate that they actually tried to have an intervention. So he actually showed his concern. And once again, I think the defense attorney should have just stayed with her questions and not elaborated, because the last two I don't think helped her.
Yeah, and what about the idea in your mind? I know I, as a prosecutor, would want to be eliminating any other potential suspect, and that's why a thorough investigation and not jumping to conclusions is important, even when you know at the scene or during your investigation that this is the person that did it. You got to prove it in a courtroom, and you want to be able to show that we investigated. We didn't just stop there, but we investigated multiple other potential areas that could come up with no other motive, suspect, or reason why this happened. Thoughts?
Oh, I think that's very important, and it's crucial, Bob, because it really lays a underlying rhythm to your whole prosecution, that we're not just coming here based upon an idea we thought of. We investigated every avenue. We eliminated potential suspects. We came here after we completed our investigation thoroughly, and that gives the prosecution credibility.
Yeah, so even though, like I was saying before, it's not necessarily the most exciting testimony, when you're going through all the investigative steps, including the timeline and the phone records and all of that, they kind of sandwich that in the middle of the case because they know the jury will get the overall point. But that is really important, is it not, Michael?
You can't build a strong house without a strong foundation. And, a foundation is very simple. It's strong brick and mortar that supports the rest of the house. It's not great to look at. It's probably not very interesting to watch them build that wall, but it needs to be done if you're going to support what you're building.
Mike, talk to us a little bit about the importance of the credibility of the lawyers and how that can affect the outcome of a case in terms of how the jury perceives you as a professional. Does that have a major impact, even though they're told only to listen to the evidence that's produced and the law that I charge you with? How important is credibility with the lawyers, with the jury?
I happen to think it's extremely important. I think many of our colleagues feel the same way. If you as the lawyer have to maintain the attention of the jury so they focus on things that'll help your client. If you start cross-examining everything and start questioning things that are irrelevant, that really don't either hurt or help you, it looks like you have no story to match the story the prosecution's giving. You have to be consistent and maintain credibility, because if you ask questions about everything and some of the answers have no effect, the jury will stop listening to you.
Yeah, excellent point, Mike. Okay, we're going to take a quick break here at the Law and Crime Network. We'll be back with more on the other side. Please stay with us. All right, we're back live in the RG case. Right now, Detective Christopher Martineau from the New Jersey State Police is on the witness stand. Let's go back live to court.
Is one travel route by car depicted in this exhibit, which is State's Exhibit 37?
Yes, it is.
The next slide is State's Exhibit 28, which the jurors have seen before. Do you see the truck that's circled in white here?
I do.
So looking at the direction that truck is heading on West Road to the left, if we can go back to State's Exhibit 37, is this route one would take from 118 West Road to Home Depot in the direction that truck was heading in the photo that we just saw?
Yes.
So going back to this photo, if this truck were heading to Home Depot, this route is one that it could take.
It is, yes.
And you said you actually did recover surveillance footage from the Home Depot in Londonderry?
I did.
And from what areas of the Home Depot did you recover surveillance footage?
From 3 different angles, from the self-checkout register department area to the exit, one of the exit doors, and the parking lot.
And I just read for the jurors a certification from State's Exhibit 1, which is a certification from Home Depot. It has attached to it a disc, a surveillance disc, and you actually reviewed this and initialed and dated it, right?
Correct.
So you reviewed the surveillance footage that we're going to be going over momentarily?
I did, yes.
start with the clip that's labeled on the bottom left, SCO. In what area of the Home Depot does this depict?
The self-checkout area?
So self-checkout area, so someone can scan his or her items and pay for it without a cashier's assistance?
Correct, yes, they can.
With respect to the date and timestamp located on the bottom left-hand corner, were those date and timestamps embedded in the videos when you recovered them, or were they added afterwards?
They were there when I recovered the video.
As to this red circle in this particular video clip, was that something that was added afterwards?
Yes, it was.
The recovered surveillance from Home Depot, did it have audio that accompanied the video, or is it just, was it just video?
It was just video.
Okay, so we'll play this first clip, and we'll play about the first minute or so. And should jurors be focusing their attention in that red circled area?
Yes, they should.
So we can play, and again, we'll play about the first minute or so. And if we can pause right here, please. And we'll go on to the next slide, which is State's Exhibit 15. Are these still photos from the video footage that we just reviewed?
Yes, they are.
So with respect to the photograph on the upper left, the next slide, is this going to be a blow-up?
Yes.
And are you familiar with the self-checkout area that's depicted in this surveillance footage?
Yes, I am.
And what area of the self-checkout register is the person in the video from which the still is taken? What area is that person reaching for?
The area where you would receive your receipt and or any cash that's returned to you.
Moving on to the other surveillance still in State's Exhibit 15. The person circled in red who just made the purchase at the self-checkout on the upper right, what area of the store is he walking to, over to the right in this photo?
Towards the exit of the Home Depot.
And does the next video surveillance footage that we'll be viewing depict that exit area where he is walking to?
Yes, it does.
So let's play the second portion of surveillance video, and we'll play the first 11 seconds or so. And before we do, where should the jurors be focusing their attention?
On the left-hand side of the screen, approximately halfway up.
Sorry. So this area right here where I'm pointing the laser pointer at?
Yes.
And again, we're only going to be playing 11 seconds, so it goes by fast.
Yes, sir.
If you can play that. There's somebody walking towards us in the view.
They are.
And if we can pause, please. Now we're on State's Exhibit 16. Are these still photos from the video surveillance that we just saw?
Yes.
And, I want to focus on the photo on the right, which is circled. The next slide, do we have an enlargement?
Yes.
And the person appears to be holding a bag?
Yes.
And where generally is the person with the bag walking to?
Towards the exit of the Home Depot.
And does the last surveillance footage that we'll be viewing depict that parking area where he's walking to?
Yes, it does.
So let's play that last portion of surveillance footage, and we're going to play its entirety, which is about a minute long. Again, it's the red circled area where we're focusing our attention on,
Yes.
and that has been added after you see the surveillance video.
Correct, yes, it has.
And from where in this video will someone be walking to that truck that's circled in red?
Again, approximately halfway up on the left-hand side of the screen.
So from this area over here that I'm pointing to, the laser pointer?
Yes.
So again, this is about a minute, if we can now play that. See somebody starting to walk towards that circle vehicle now?
Yes.
Next slide, we have State's Exhibit 17, and are these still photos from the surveillance video that we just saw?
Yes, they are.
With respect to the truck leaving the parking lot, it may be difficult for you to see, so I do have State's Exhibit 17. According to the embedded date and timestamp, about when does that truck leave the parking area?
Approximately 9:11, 9:12 in the morning.
So about 9:11 in the morning?
Yes, sir.
And going back to the slide showing the approximate travel distance and time between that Home Depot and 118 West Road, you said again it's about 15-minute travel time?
Yes.
So adding that 15 minutes or so to approximately 9:11, so that takes us to about 9:26 a.m., is that fair?
Yes.
Show you State's Exhibit 29, which is a still surveillance photo that the jurors saw earlier. Do you see in this still that what appears to be the same truck circled in white?
Yes.
And about how much of a time difference is depicted in this photo, which is 8:41 from the estimated travel time that we got before, which is about 9:26. So what's the difference between 8:41 and 9:26?
Approximately 45 minutes.
I'm showing you a slide that the jurors saw before State's Exhibit 33, which shows a time difference of 41 minutes. Is that correct?
Yes.
Switching gears to another topic, you said that as part of the investigation into Maureen Argy's death, you spoke with James Timbus and he allowed you to photograph text messages from his cell phone?
Yes.
Did Mr. Timbus also give you a debit card?
Yes, he did.
And in whose name was that debit card?
William Arbery.
Hi, Mike Koribanics. It comes to the end of the day for me and you. I want to thank you for being here from 12 to 3, providing your excellent legal analysis. This witness, the whole witness, the case as a whole, how do you think it's going in for the prosecution today?
Well, there hasn't been much that the defense has been able to rebut, so I think they're building a strong foundation. It's going in well.
Yeah. So, what do you anticipate in terms of you think it's going to come down to a battle of the medical experts as to cause and manner of death in this case, Mike?
Yeah, Bob, and you said that earlier before we heard some of these witnesses, and I couldn't agree with you more. And I think basically they're just setting this up so when they listen to the medical experts, the jury's going to have a total context in which they're listening to their opinions.
Although they got some pretty good motive evidence out today, don't you think, to support that medical examiner's testimony?
Absolutely. Absolutely. I think they got a lot of testimony out, and I think these people who dealt with the victim in this matter daily and things of that nature, telling their story about it, has a very strong influence on the jury.
All right, Mike Koribanics, law and crime legal analyst. We greatly appreciate it. That's it for me for right now, but don't go anywhere because the great Michael Bryant is next. We'll be right back.